in section 204.1, reasonable time is defined as 24 hours a day, office hours. I'd also like to mention that an expansive reading of statutes would be appropriate in this situation. In this court's case, Anderson and Straker, I believe that was pronounced. This is 93-102, what is the student term for? The student body is entitled to full and efficacious vote. The court also held in that case that it's a fundamental right of the student body, the power to elect student representatives, and the student Supreme Court is the primary guardian of this fundamental student right. And I believe this court has a very important power for it today to find that the student body has spoken in such a large quantity. The United Party was elected a 74% margin in the presidential and vice presidential race.
Ms. Blair, let me ask you a question. I understand your point that the student body has spoken in this case, and in the election, the United Party won by an overwhelming majority. But do you think that it's the will of the student body to put officials into office that can't follow a very simple procedure?
I think that, respectfully, Your Honor, if the student body was asked that issue, that they would find that this was a mere accidental human error and that all candidates for office are indeed human.
Can you distinguish an accidental human error from blatant noncompliance?
I can, Your Honor, as was specified to our Elections Commission meeting, and could also be given in a written statement should the court require it. My clients will absolutely have testified that there was a faith in that state that they covered to include everything that we thought they should.
Ms. Blair, what about the fact that the cover sheet has the 5 requirements and requires the party to sign that sheet?
Your Honor, I cannot personally explain why the error was made. However, the party there necessarily there was in fact a coordinated whatsoever that it was a misstatement of on purpose. I can also assert that the party has nothing to hide, so there would be no purpose for them to do this. When everything was turned in there this morning, it was found to be complete, and nothing was in violation as far as the financial records.
Ms. Blair, you give so much weight to the student body. Is it your argument before the court today that we should ignore the statute?
Absolutely not. I just think that the court needs to take a little reading as to the fact that it does not specifically state that there's what a punishment would be for an incomplete financial document. I think that the courts should look at the state statutes or just use their own deference and logic to infer that it would not be, it should not be a worse punishment than a fraudulent financial record.
Ms. Blair, so what is it that you're requesting to do? Or what do you think would be the appropriate remedy in this case?
An appropriate remedy would be to follow a Schedule 2 violation with fines and some surcharges and my time is up. So I'd like to conclude by saying that I respectfully request the court to find a reverse decision.
Thank you, Ms. Blair. You have 5 minutes left.
May it please the court, Chief Justice, and Justices of the Student Supreme Court. My name is Janito Simon, and I represent the Student Election Commission, UPenn. The issue for consideration today is whether the commission erred in deciding to dismiss the Ignite candidate for violation of student body statute. The answer to that question is very simple, yet emphatic yes. I'm sorry, the answer to that question is very simple, yet emphatic no. It did not err. Giving deference to the judgment of the commission, because logic mandates
be recalled.
Your Honor, I would refer the court to statute 702E16, in which it is specifically enumerated in the student body statute that in order to avoid miscarriage of justice, the commission can, at its discretion, have the opportunity to make a ruling so that it doesn't violate or so that there's not a
So,
miscarriage of
Counselor,
justice.
basically you're saying that the election commission does not have the authority to issue this particular remedy, but they only have the authority to issue something that would avoid a miscarriage of justice.
Your Honor, under statute 715.9, it was in the purview of the student body election that upon finding the violation and per the code, it's immediate dismissal or immediate disqualification. That's 715.9 student statute. In fact, the statute is also very clear and unambiguous as to exactly what a final expense report should be. It states in 714.3b that a final expense statement shall include 5